Welcome to part two of the Congress, the legislative branch, and now we're looking at congressional behavior. Think of gerrymandering, think of redistricting, reapportionment. The role of Congress and how Congress creates public policy is what we're going to cover in this part of the legislative branch chapter overview. Thank you for joining me. So, what do you think? Do members in Congress from the president's party have an obligation to support the president's policies? Do members in Congress from the opposite party have an obligation to be the loyal opposition, or should they support the president's policies? Is it okay for the opposing party to decide to oppose everything and just be the loyal opposition, even if there's something in it for their constituents? And why might some argue that it's good strategy for an opposing party to always oppose the president? Why is that? We're going to take a look at that in this part of the Congress, the legislative branch. So party polarization is this idea that we have an ideological split between Democrats and Republicans. We know that this is a generalization. We know that there's a lot of people, and we can look at moderate Republicans and moderate Democrats that tend to kind of blur the lines. But there's a lot more of this ideological division today, and it's increasing, okay? Some of the causes of this are clear differences on issues. And you can look at the social issues. You can look at the budgetary or fiscal issues that are taking place. The ideologies of voters in these states that are safe, in states that particularly lean one way or the other, are less swing. Those create party polarization. And what this does is it creates gridlock. It limits the power of government. Fewer bills get passed. I would argue also that fewer good bills, good legislation to help the American people gets passed. You have more filibusters. You have more more time spent in procedural aspects than in actually carrying out the will of the people. And you have much more difficult confirmation proceedings. And we're definitely seeing that in terms of the role that Republicans and Democrats are playing in this judicial nominee. Right? You see the Republicans on one side, you see the Democrats on the other, and never the twain shall meet. There's not a whole lot of common ground in between them. So we definitely see clear lines that are drawn here. Now, notice here we have members that are mostly liberal or mostly conservative in terms of the members of the caucus and how that has taken shape over time. Notice the differences here from 1980s just to 2012, just in 30 years, how different those caucuses have become. Caucuses, again, meaning areas of interest, and political party being definitely one of those. We see a lot more members reaching across the aisle. I will tell you, when I served, when I worked in the Senate, you saw a lot more of the reaching across the aisle and people working together. I remember working in press and looking at the idea of press conferences. We had a lot of press conferences with the members of the other party because there were ways in which we could find agreement and work with the other side to find common sense legislation. You wouldn't see any of that today, very little, if any. And you can see it is significantly changed in terms of, just in 30 years, it has significantly changed in terms of that party polarization, in terms of what we see here. So what does that bring about? Well, it limits government's power to do things for the American people. It leads to a divided government. It leads to gridlock. Less gets done. Less work for the American people. And that leads to policy that is slow. It's inefficient. It doesn't help the people that need it the most. And so, especially in an epidemic, a global pandemic, you see the people that aren't getting the benefits, that aren't benefiting from the coronavirus relief bills that aren't getting passed. It's not getting to the people that need it the most, and that really is the sad part of gridlock. That really is the sad part of limited government. And we see along both sides in terms of how this is positive and negative in terms of carrying out. And we'll have a discussion in class about that in terms of the roles that the policy plays here, and in terms of the impact of party control and the presidency in terms of carrying out the policy agenda. Elections do have consequences. Lindsey Graham was right about that when he said that I am going to vote for President Obama's nominees back in the 2000s. he said that because he said, I can't oppose these justices to the court, these nominees, because they are qualified. They are highly qualified individuals. And elections have consequences. Democrats won, and I'm going to vote for them. I'm not sure that he would be of the same mindset today in terms of that. I think party polarization has changed his mind on a lot of those types of issues. We saw that with Merrick Garland just at the end of the Obama years in 2016, in terms of that playing out with the death of Antonin Scalia. So to be continued, but we're going to continue, unless something changes, we're going to see continuation of this party polarization. Now, that leads us to, so why is it so polarized? How did we get here? Well, it came about because of the idea of reapportionment and redistricting. What does this mean? Reapportionment is the idea that we take a census every 10 years. We're in the middle of one right now. And the idea here, and the Supreme Court just ruled that it can end. The Trump administration was fighting a Supreme Court case that basically said they wanted to close down the census early and in order to get information to the president in time for the end of the year, and it was being fought because the concern was people wouldn't be counted in those numbers. But the Supreme Court just ruled today that they can close that down. Again, elections have consequences. So the census basically comes up with the numbers of how many people live in the United States, and that includes everybody that is living in the United States of America, and then they divide that by 435. That number becomes divided by 435, the number of people in the House of Representatives, and this basically reapportions the House seats to make sure that every district is about the same size. So in 2010, we took the population, which was about 300 million people. We divided it by 435, and we got about 720,000 people in each district. Then that's the reapportionment piece. So then what we do, they look at each individual state. Maryland, for instance, they looked at that 700,000 number, and they said, hey, Maryland, you have about 5.6 million people in the state of Maryland. So divide 5.6 million by 700,000, and you get about 8 seats. And so we have 8 members of the House of Representatives from the state of Maryland as a result of that reapportionment. Now, what the state will end up doing is redistricting. The state will redistrict those 8 House seats to divide up that 5.6 million people across the state into each one of 8 districts that will be equal to about 700,000 people. How they do that is very political in nature, but that redistricting is creating those 8 districts, and that's what we're going to talk about here. So reapportionment, you're changing the number of seats that each state has in the House of Representatives. Again, taking the total population, dividing it by 435, that tells you how much each district, in terms of population, how much each district has to have in each of those House districts. They're going to do that every 10 years as a result of the numbers that they're getting from the census. Now, redistricting is going to redraw those lines. States are going to do that, and they're going to follow reapportionment in terms of how many how many member seats they're going to be given. In Maryland, in 2010, we were given 8 seats. So we were able to draw from that, redistrict 8 seats across the state for the 5.6 million people living there into equal districts of the same amount of population in each of those districts. And that comes from the case of Baker versus Carr, because the Supreme Court basically ruled that each district should be about the same size and population as every other district, no matter where it is in the country, with some exceptions. Now, obviously, every state gets at least one member in the House of Representatives. So if their population falls below that 700,000 number, they still get 1. Wyoming is a great example of this. They have about 400,000 people in the state of Wyoming. 400,000. But they still get 1 seat, which means you're going to have to make up those 300,000 somewhere else in the other 434 House seats that are spread across the country. But the idea is the same. Other than that, one person equals one vote in every district. So about 700,000 people in each district in every district across the country. One person equals one vote no matter where you are, whether you're in Walla Walla, Washington, or whether you are in Waxahachie, Texas. One person equals one vote. Okay. Now, what this led to and was a result of was malapportionment. Some states decided, hey, we're not going to redistrict every 10 years. We get the same amount we had before, we're going to leave it. And what this did was it created districts that were very unequal in nature, because as populations grew in some places, they diminished in other places. And that led to some districts getting better representation than others, this idea of malapportionment. And so the Supreme Court ruled this unconstitutional. They said it's a violation of equal protection and equal representation. As a result, this idea of one person equals one vote should be the law of the land. This should be carried out. And so in 1962, they ruled that this malapportionment was unconstitutional. The court conclusion basically saying here that proportional representation states must go back and redistrict every 10 years to redistrict the districts they have, so that each district in the state is equal, roughly equal, to every other district in that state. So no matter which district you go to in the state of Maryland, you should be able to go to all of the other districts and see the same amount of population from the 2010 census data. Now in 2020, they'll do the same thing. They'll get the numbers from the census, and the Commerce Department will reapportion those districts, divide by 435, the total population by 435, and they will give to the states how many members they get. They will then, each state will redistrict according to those members. And there is an explainer here in the chapter notes if you want to see this, that I think will help you in terms of explaining that. Now, how the states go about doing this is open to interpretation, and definitely the Supreme Court has ruled that this is a political question, not a constitutional one, which is really important. So in this, we have what's called gerrymandering, and that's the bizarre shapes and sizes of districts that are created in order to protect incumbents, in order to benefit political parties, and in order to increase minority representation in some places. Now, there are some rules to this. And the court has ruled that they have to be contiguous. They can't disconnect. It's all got to connect in some way, shape, or form. Sometimes even a highway is that connection, and they're fine with that. It also it should be as compact as possible. Now, you can see that rule has kind of gone the way of the dinosaur. It also should be concise, and again, that is much diluted in terms of what we see here. There's some other aspects, though, and this is the idea of the cracking and packing. You can't dilute minority voting strength by packing them all into one district, and then they're not represented in the other district. That has been ruled unconstitutional by the Supreme Court. And you also can't just draw these based only on race, because the idea of cracking or packing, the idea of cracking up minority voting strength and diluting that to the point that they don't get representation that they otherwise would, is also a violation of the Constitution. So gerrymandering, very important here in terms of the political questions that are involved. The Supreme Court did get involved in the minority aspects of representation in these districts by saying that's unconstitutional, but otherwise they really take a step back in trying to stay away from political questions. And the districts in the state of Maryland, the districts in Wisconsin, they really stayed away from those and said these are political questions that political parties that are in power in these states should resolve, not us. There was a time when they did step in, again, because it was minority representation in Texas, for instance, when the lines were being redrawn. I think that was 2004, when the lines were redrawn in Texas, and they ruled those unconstitutional, and they mandated that the state go back and redraw them. I believe last year they did the same to Pennsylvania because of diluting minority voting strength in those states. So those are some questions that the state steps in, and you're like, hold on, Rodman, I don't understand, like, how is this gerrymandering actually taking place? Well, let's show you in the Stealing an Election for Dummies book here on how to steal an election using these methods. Notice in the in the first column here, we have 50 precincts. 60% of them are blue and 40% of them are red. By gerrymandering, by doing the idea of cracking and packing, and again, this is splitting voters into multiple districts to dilute their voting strength, or packing them into one district to have all the voting power and getting them out of the other districts, they're essentially changing the outcomes of these elections in terms of who would win. So notice in the middle column, you see how this breaks down. If they did this just by 5 districts, you'd have 5 blue that are winning and no red that are winning in terms of this. That is one way. Again, compact contiguous doesn't dilute voting strength. This is what we would see as being constitutional. But notice the one on the right. What they've done here is they've basically created districts that do the cracking and packing approach, that pack all of the blue into a couple of districts and crack them out of a couple of other districts. And what it does is it carves out 3 districts that then become red that otherwise weren't red before. So it really does matter how a state decides to gerrymander or to redistrict each of these House districts, because you can end up with a result that is 5 blue and 0 red, or 3 red and 2 blue, or you can even go other routes as well that, again, with cracking and packing, can really significantly impact the outcome of these elections. And that's what the Supreme Court was trying to avoid, especially when it came down to equal protection issues in terms of minorities and race and ethnicity. This was really the hard part in terms of trying to address it. Now notice, same map, but we've added perfect representation here in terms of what they're looking at. You've got 3 blue districts, 2 red districts, blue wins, but again, you've got representation from both parties in terms of those districts. Here we've got compact districts, but they are unfair in that and this is typical gerrymandering. They're compact, but they are unfair in terms of 5 blue districts but 0 red. This is what they did, the Democrats did in the 6th district, the western part of Maryland. They basically were compact in drawing in enough Montgomery County Democratic voters into that 6th district to flip it, to make it Democratic. And so it went from Republican hands before 2010 to a Democratic district in 2010 as a result of the redistricting there. And this is neither compact nor fair. Would be really hard to justify in the courts in terms of cracking and packing. And that's really the issue of gerrymandering that we're trying to address, that the court is trying to address there. So notice here is 2002's map, as I mentioned. This is the 6th district in purple here. And then notice how they've basically divided it up, and they pulled in parts of Montgomery County into that 6th district that wasn't there before in order to bring in more Democratic votes. And it flipped the district. It changed the district from Republican to Democrat as a result. The 8th district was already Democrat, and it added in some more Republican areas to more Democratic areas to become more Democratic. But they picked up a seat. Democrats picked up a seat in the 6th district as a result of this. And basically 7 of the 8 districts now are Democratic seats because of that redistricting process. So this really does play out and make a difference. Now, again, the courts stepped in and said, this is a political question. These are constitutional for now, as long as they're not addressing race and ethnicity as diluting minority voting strength. We're going to stay out of it, and they did. There is a really fun game, if you want to look it up. There's a link on the chapter notes here to the redistricting game, but it is a fun one that you'll love. I'm not sure how much longer it's going to be around, because I think it is based on Flash, using Flash on the Chromebook or on the Google Chrome. But it is a fun game in terms of how hard it is to redistrict and make your constituents happy over time. I think you'll get a kick out of it in those terms. Okay, so what do you think? In your opinion, should partisan gerrymandering be allowed? We're going to talk about that in class and address it. We've got some other resources to address here in terms of praising partisan gerrymandering. We see people on both sides of the aisle trying to address this issue in their favor. We saw Wisconsin, Republicans were redrawing the lines to favor themselves. We saw Democrats in Maryland doing it. We saw Republicans in Pennsylvania doing it. So we see states all over that are trying to do this gerrymandering in ways that are going to help them. But the issue remains. We don't want it to affect racial on racial lines. And this brings up the case of Shaw v. Reno, where congressional districts were actually drawn based on race. And the Supreme Court shot this down and said, no way is this a good way to be redistricting. This is unconstitutional. There is an explainer on this in the next slide, but basically the Supreme Court stepped in and said, we're going to allow majority-minority districts. That's okay. But if you're cracking and packing and breaking up racial groups in order to dilute their voting strength, that is not okay. And this is not allowed in terms of trying to redistrict in this manner. So there is an explainer related to this that I think you'll find helpful, but it really goes into how the Supreme Court ruled on this issue and why. In terms of that there. Okay, so let's shift gears for a moment and talk about this idea of congressional representation. There are three models of this that we see today. The first one is the trustee model. I call it the trustee, trust me, because I'm going to vote the way I think is best. And that is the one we see most common today. Very much how I personally believe is how I'm going to vote. We see most members will vote that model. We do, on occasion, especially in swing districts, see the delegate model. Susan Collins, for instance, in an election year is going to vote the delegate model. She's going to do what the constituents want, not necessarily what she wants, because she's trying to get reelected. We see the same thing playing out in other swing districts. And then we've got the political model. Sometimes one, sometimes the other. And this is where in House districts, we would see more the political model because you would see someone act as a trustee in cases and a delegate in others. But the idea is the same in that if there's less to lose as a result of your swing district, you're probably going to vote the trustee model if you're in a safer district or you're in a 6-year term as opposed to a 2-year one. That can make all the difference in the world. So looking at this, we have different congressional representation models, and I think you can pause this and take a look at what they are. But these are essentially the backbone of the way members of Congress vote today and the roles that they play within it. So the House and the Senate kind of go back and forth in terms of what we see here. We see a representative more likely to act as a delegate model because they're closer to the people, they're up for re-election more, and they want to make sure that they're listening to the needs of the people. That was by design. The founders and framers made that way. And we're going to see senators that take more of the trustee, trust me model because they have more time. They're probably in a safer seat. And if they're not, maybe they take the political model where they kind of break up the two. But that's kind of how the House and Senate break based on party polarization, based on whether they're in a safe seat or not, based on whether they're up for re-election more or less. That really does make a big difference. Through this, I actually did find a really neat piece. If you're interested in this subject, Is Congress the Broken Branch? Taking an in-depth look at how Congress has changed over the last 100 years, 50 years really, and how party polarization has really changed that. The role of money with the Citizens United case, really allowing outside groups to raise unlimited amounts of money and inject it into campaigns, how that has changed the role of Congress. All of these are significant in terms of the changes that are taking place here. So if you have time to take a look at that, I would encourage you to do so. So take a look at the review questions here on reapportionment, redistricting, gerrymandering, Baker versus Carr, Shaw v. Reno, the Politico model versus trustee and delegate, the delegated model. If you can't answer these questions, I'd go back to the video and rewind and watch those parts again. Hopefully you'll find those helpful. We're going to go on to the next and final part in this video, which is 2.15, which is the idea of public policy and the branches of government. So this is kind of incorporating, so how does all of this relate to the policy agenda? We've looked at the how we get it done side. Now let's look at the public policy side of things. So public policy is this course of action. It's the outcome. It's what we want to end up as a result of a bill that gets passed by Congress, made into a law, and signed into law by the president. And as you can see, that is done in the signing legislation, the signing ceremonies that are taking place here. We see this with the Bush administration, the Obama administration, and the Trump administration. This is the outcome. This is the result of action that Congress is addressing, trying to address a problem, trying to ameliorate an issue or a challenge that the American people are dealing with, and trying to do it in a way that is helping the American people in the long run. So what are the steps to take in making this public policy public? In making it the law. They sit down and try and address these issues. They talk about them. We see protests in terms of trying to address the need for change. We saw a lot of that with the Black Lives Matter movement this summer, in terms of trying to address the fact that there are inequities in the system, that there are areas, as Amy Coney Barrett said in the judicial hearing today, that there are in the judicial system areas of implicit bias, because just by the size and scope of the system, there are problems that need to be addressed. And we see this throughout. It is endemic of a system that is as large as ours. So what are the steps to making this policy today? Well, first you have to make some assumptions about the problem in terms of what is the problem. How do we set the agenda? How do we decide what to do and how much of that to do? What solutions are we going to choose from? What options do we have? How are we going to actually carry this out? What goods or services will be delivered? How are we going to deliver them? And what rules are we going to set for the bureaucracy, the administration, the executive branch to actually carry this out and actually run the program? And then how are we going to follow up on this in order to make sure, with investigations and hearings and questions that we ask, how are we going to make sure that this is actually being carried out? So these are the steps to public policy being created. And how do we, again, going back to the issues of the bicameral Congress, how do we make sure that the legislation that gets passed is good legislation, is solid legislation that is being created for the concerns and the will of the people? Those are really the aspects that we're trying to address here. So how do citizens influence this process? Well, voting, number one, right? We talked about this. Voting is the number one way we can influence policy, because voting means elections have consequences. And the people in Congress that are carrying out the policy agenda, that are prioritizing your issues, are brought about and elected because of voting. So if you're not voting, you're missing the most important thing. So make a plan to vote, right? And make sure that your parents and your grandparents and your extended family and friends are voting. This is critical to public policy being implemented and created. We need to be educated. We need to be informed of these issues. That's why we're in government class. We need to be educated and informed on these issues. And we need to make our voices heard. We need to express those opinions. We need to write letters, make phone calls. We need to post on social media. We need to sign petitions and start petitions. We need to make those voices heard. We need to do whatever we can in order to get those voices out there and to support those individuals, including joining interest groups, supporting political parties, supporting interest groups and political positions that they're taking on these policy issues. All of these are all about how we can influence that process. And we have a significant role in terms of how that plays out. But we have to do these things. We can't assume that the neighbor's going to do them. We can't assume that the guy or gal down the road is going to do them. We need to take that action and do it, and then encourage those around us, those in our spheres of influence, to do them as well. So once we get this idea of what we want and when we want it and how we're going to carry it out and what public policy we've created, we need to write a bill. We need to introduce that bill. And the idea here is we're going to introduce it. If it's a tax law, it has to start in the House. If it's any legislation that's non-tax or revenue-based, it can start in the Senate. So it really doesn't matter which chamber it starts with. But the idea here is it's going to start in the House of Representatives. It will then be referred to a committee, and the committee will usually give it to a subcommittee. That subcommittee will then usually find hopefully ways to incorporate it, ask questions, call in expert witnesses, ask questions about it, and if it is good legislation, not kill it. Because most legislation that is a bill dies on the subcommittee floor or on the committee floor. Most of them don't make it out of committee. But remember, the real work gets done in committee. So it's not surprising that the thousands of bills that are introduced in a Congress in a 2-year term actually end up dying in committee. This is the nature of the beast. But the idea is that the legislation, the couple of hundred or few hundred bills that do get signed into law are good legislation, are really good pieces of legislation that promote the will of the people and are beneficial to the American people. That's really the role here. So if it makes it out of subcommittee, makes it to the full committee, and makes it out of there, it then goes to the Rules Committee. The Rules Committee decides to prioritize it, decides on how much debate it gets, how many people on each side speak, for how long, and then when we actually vote on the bill. If the floor action happens and the vote is taken and the bill passes, it's then going to go over to the Senate. And then the Senate will take on the same legislation. The process starts all over. Here, we don't have a Rules Committee, but we do have committee action, so it's going to go to subcommittee, then to a full committee. If it passes out of there, it would go to the majority leader, who then determines, like a Rules Committee, the majority leader has the sweeping power here, the Speaker having the power here, but the Rules Committee is all chosen by the Speaker. So the majority leader in the Senate is going to determine when the bill gets brought up for a vote, how long people speak on it, and how long they're going to debate it, and when they call for a vote. Then, once both of those bills have passed, we'll look at the House bill, we'll look at the Senate bill. A conference committee will decide what changes need to be made in order to go back to both chambers for an up or down vote. Then that legislation will move on to the president. Once both chambers have signed an identical bill that passes both chambers of Congress, only then does it go on to the president. Okay, and then the president can sign it, veto it, or pocket veto it. And we'll look at that in the next segment. So to sum it up, I like this graphic better because I think it kind of highlights what we see there with, it's a little easier on the eyes, not quite so much yellow there, which is really kind of hard to read. But again, tax and revenue bills are introduced in the House. They're referred to a committee, which then sends them to a subcommittee. If it makes it out of full committee, it goes to the Rules Committee. And the Rules Committee determines who is going to pass it, who is going to sign it, and then it is sent to the floor for debate, for action. The Rules Committee is going to decide who is voting on this, who's going to speak on this, what kind of amendments are going to be. Is it closed rule or open rule, meaning closed rule, no amendments, open rule, all kinds of amendments being offered, and how many people are going to get to speak on each side. How long are they going to get to speak, and when are we bringing this up for a vote? We do the same thing in the Senate, only there's no Rules Committee, so essentially the majority leader is choosing that action. And again, if both the House and Senate have different versions, a conference committee is going to work out those details. They're going to send it back to both the House and the Senate for an up or down vote. And if the identical bill in both chambers gets passed, it then moves on to the president. The president can sign it into law, and that's that signing ceremony we saw just a second ago. The president can veto that bill. The Congress can override it, though, with a supermajority, 2/3 vote by both the House and the Senate can override that veto. Or the president can pocket veto that legislation. The president has 10 business days, that's 10 days not including Sundays, to vote on it. And pocket veto is basically leaving it on his desk. And if it stays on his desk for 10 days, not including Sundays, and Congress is in session, then the bill becomes law. If Congress is out of session, then the bill dies. And that's really where a pocket veto is most significant, because the president can pocket veto it. Why would the president pocket veto? Because maybe they didn't want to veto the bill because of the negative media hype that would be around negatively vetoing a bill. And so they just want the bill to die and go away. That would be great for a pocket veto in terms of how to address that. So that's the role that would play there. So the president has 3 options, and And those are the three. So introducing a bill in Congress, only members can introduce a bill in their respective chambers. So a senator cannot introduce a bill in the House, and likewise a House member cannot introduce a bill in the Senate. They can introduce it in their respective chambers. Okay. Then they're referred to committee and likely subcommittees in that case. And the committee chair determines the agenda for that particular bill. Again, most bills, thousands of bills, are introduced in a 2-year Congress. Only a couple hundred at most are actually signed into law, actually make it that far. And the idea is that the committees are controlled by the majority party. So, minority party, you can introduce a bill. If it doesn't have bipartisan support, it's probably going to die. And so your question is, I get this question a lot. So why, Rodman, would people bring up a bill knowing it was going to die? Well, a lot of times they're also trying to put out a trial balloon. They're trying to test the waters to see what kind of reaction they're going to get from members, from the press, from the public, from those publics that are out there, to see if there really is some good feedback on the bill, maybe to make it better, or to see what kind of critical mass is developing around an idea for this bill. And so that's so a lot of times bills that pass have been introduced in previous Congresses. Now, if the bill dies, it cannot be brought up again in this 2-year cycle, but it can be brought up again in a later cycle, and that's really important here. But again, it's important to remember that the majority party controls committees. So if they are not in support of your bill, they are probably going to kill it. If you are a member of the minority party and you're trying to get legislation passed, it is a good idea for you to use it as a bellwether, as a trial balloon, but it's probably not going anywhere. So it's good for you to put it out there, but keep in mind that it probably will die. Now, a lot of the testimony is going to take place in hearings. The markup is going to take place in a committee markup, and then votes are going to take place in committees as well. But again, we're going to see more of the voting aspect on the floor, where we see here the speeches and the debates. But the real work gets done in committees, and we're going to see that play out. Now, the House Rules Committee is going to set the rules. This is unique in that the House only has this. Closed rule is going to basically close down all amendments. Open rule, you can have all the amendments you want to, and maybe they'll have some open rule with some caveats in terms of it can only be particular aspects. You know, there is germaneness. It's got to be relevant to the policy topic. You can't just throw anything in there. But the House Rules Committee is going to have that power. And again, they're given that power by the Speaker, who has sweeping powers. The Speaker is the most powerful in the Congress, and there is a reason for that. The Speaker has sweeping powers in controlling the agenda of 435 members in the House of Representatives, and the tyranny of the majority, the whims of the masses. The majority rules in the Senate, or excuse me, in the House. It's in the Senate that the minority is protected by things like the filibuster. So the floor debate is very different here. There is no rule on debate, on limiting debate or germaneness. So that's why we see filibusters time and again. The role that is being played here. So very different. Again, the minority is protected in the Senate. The majority rules in the House. The minority is protected in the Senate, and that's kind of how that has worked. Now, there are some debates about whether that's really effective anymore in terms of the role that's played, but that is the role that we have seen traditionally, historically, in the House and Senate. Conference committees, again, if there are differences in House and Senate versions, as I mentioned, the conference committee is going to work out those details. Again, the Speaker on the House side, the majority leader on the Senate side, is going to appoint people who are going to represent the House and Senate in this conference committee, and they are going to basically find a way to come up with a bill that both the House and Senate can be happy with for an up or down vote. Once that up or down vote is identical to House and Senate legislation that's passed, then it goes on to the President and becomes law. And that is in final form. So the President, as I mentioned, can sign it. They can veto it. Again, an override with a 2/3 supermajority of both houses of Congress can override that veto. It doesn't happen very often. And then the President can pocket veto that bill, which again, for 10 days, not counting Sundays, if Congress is in session, the bill becomes law. If not, the bill is going to die. Okay, and that is the role to play there. So, how do members make decisions on so many bills? I mean, yay, nay, vote present. What am I doing here? This is lots of ways. They take lots of feedback and information. It's really interesting because we talk about when we look at interest groups, the most important role that an interest group can play to a member of Congress running for re-election is money. But the most important role an interest group can play to a member of Congress outside of an election is information. And that information is critical. So with 8,000 bills being introduced in Congress, each Congress, every 2 years in this biennial term, they're really reliant, and they're not experts in all of these areas, as you can imagine. So they have staff that help them with this, but they're really reliant on outside information. So they're relying on colleagues, and some of the committees, the staff of those committees that are doing research and finding out more. Hearings, calling in expert witnesses and asking them questions and getting feedback from them is also helping here. Having staff do research and advising them. Hearing from constituents, and there is strength in numbers when people speak out on education, for instance, and they get tons of letters from people talking about education. All of a sudden, education becomes a much more prioritized issue on their agenda, and probably their committee's agenda, if they're in the majority, than it otherwise was, because they're hearing from constituents in terms of changing their agenda. Changing their priorities. Ideology and party obviously have a huge impact here. Interest groups, we all have them, we all listen to them. Lobbyists in those interest groups, both sides of the aisle are guilty of taking money from interest groups, of outside groups influencing their elections. We see this in both sides of the aisle, and lobbyists in doing so. And then the role of the president in setting the agenda. We see the president using the bully pulpit, the media, to set the agenda through tweets on Twitter and through other party pressures. The members of Congress are influenced greatly by the president as well as the party here in terms of how that plays out. Now, Congress doesn't have a very good approval rating. We talked about this earlier. A member of Congress that is your member, they love them, 57% approval or something like that. But the latest numbers, which I just got this off of Gallup, showed a 17% approval rating for Congress right now in 2020. That is abysmal. Now, not the lowest we've ever seen. It has been lower, but pretty low. And when you figure that the president is usually hovering in the 30s or 40s, and you have the Supreme Court, the judicial branch, in the 50s, you can see that people have a pretty low opinion of Congress. And it's because it's a body that is easy to hate. It's a group of people you don't know. Yes, I love my member of Congress, but the rest of them, throw the bums out, right? That is essentially the mantra of Congress, which is why they have such a low approval rating. It is easy to disapprove of a body that you don't hear from on a regular basis, you don't see, and you don't know what they do. And you know that they're taking your tax dollars and they're using the money, but you don't know how. And so that in and of itself is a confluence of events that leads to a low approval rating when you see this here. So there's also a lot of bureaucratic accountability. I mean, when we have pluralism, we have little accountability. So when people look at this and Congress is passing legislation, you've got oversight hearings, but maybe people don't show up. And we've seen that with the Trump administration, where people don't show up for hearings, they're not answering questions. How can you pass laws about this agency that make it work better for people when the people don't show up to answer questions? That really makes it difficult. The president can issue executive orders, but again, the idea here is the priorities are being set by the president based on ideology. And the Supreme Court and the judicial branch is looking at the constitutionality of issues and agencies and actions according to the Constitution, according to the words of our founders and framers. But again, there is a lot of implied powers that play out here that the American people don't always see and don't always hear. They hear the bad things first because the media report that, right? Like in times of war, when it bleeds, it leads. The idea there of the media. we see that that leads very much so to lower approval ratings in terms of how that plays out. And again, we love our member of Congress, 51% versus 27 in terms of how we don't necessarily approve of the people, the other people that are out there. But our member of Congress, oh, we love them. They really helped out, when we had that thing. So that really does make a big difference. The last concept I want to talk about is the legislative veto. This was ruled unconstitutional, but it is an interesting one in that Congress tried to pass a law that gave the president the authority to essentially veto individual actions that the agency was taking by a simple majority of vote. And the agency had the authority, or the president, either one, to veto actions either that the president was taking on behalf of the agency that was negatively impacting the agency, or vice versa. And the case was INS v. Chadha. And basically the Supreme Court stepped in and said, whoa, 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 this is an overstep of making laws. You don't have the power to do this. You're giving legislative power to the executive branch. We saw this in addition with the Clinton v. City of New York case, in which the line item veto was given to the president. Very similar to this, the Supreme Court ruled, I think that was in 1991, where the Supreme Court ruled that was unconstitutional. You gave too much lawmaking power to the body that was supposed to enforce and carry out the laws, and that was a violation of the Constitution. That was unconstitutional as well. So we see the courts really kind of seeing where Congress is going and kind of pulling them back in some places in order to say, hey, that's beyond your boundaries. That doesn't imply less necessary and proper clause. That isn't elastic in nature. I hope you found this helpful. Gerrymandering being a key theme here, and the legislative process. How does a bill become a law? And what happens when it does in that public policy making process? So here are some review questions related to this section. Again, pause the video and go back and reread or watch, maybe on 2 times the speed, I don't know, in terms of helping you in this particular area of agencies and addressing the issues of the legislative process. But I hope you found this helpful. This concludes part 2 of the legislative branch and public policy. And we look forward to the next chapter, in which we'll look at the executive branch and the role that the executive branch and the bureaucracy play, coming up in the next chapter. So live the 5. Have a great day. Good luck on the upcoming quiz, assessment, or AP exam. And we will see you in the next chapter on the executive branch.